Hey there everyone, it's Rob Ryder. It is May 26, 2013. Makes it a Sunday. And this video is about the seat of justice, and it's important to doing DBAs, doing business as, fictitious name registrations, whatever it ends up being called, wherever you are. My email address, and if you could donate, please do. It is the end of the month, and an electric company wants their money for a little bit longer. Snail mail and the PayPal account. And so, why is the seat of justice important to DBAs? Well, let's just start with a little story first of all. And this might get your attention. So, in the in the Florida frequently asked questions section of their business registration that you do through the Secretary of State, it said also banks and financial institutions may require proof of registration before engaging in any transactions. And later on we'll get into the definition of a transaction, but it's much more than making a deposit in a bank, running a checking account through a bank. Much, much more. So, I was told a story this week. We'll say from A, B, and C. A told me the story, heard it from B, who knows C, who it happened to. I know A, and I do know B, but never met C. So, a few years ago, a guy wanted to start his own business. And, decided to do it DBA, doing business as. With no other intention than to start a business, doing his trade. And he decided to make his business name all caps. And so he put all caps, his all capital letter name, and just so we know what we're talking about here. Alright, there's all caps, Robert Allen Rytlewski. Right, so he put all caps as the name of the business and gave it an address, and he put himself as the owner. Now I'm not sure if he did it the true name way, which is Rytlewski, Robert Allen. That is your true real name by operation of law, surname coupled with the given name. And before we go any further, if you're doing this, I don't think you should be doing a DBA in the name of the name that's on a court case or in your married name or any other thing, except do the one thing first, which is go back to the beginning of yourself, and whatever that is, use that. All right? Take care of yourself first. We'll figure out what to do with anything else anyways, but on court cases, those are fictitious names anyways. They don't exist, right? They use your middle initial, sometimes they just put your first initial, all sorts of things. It's really just a way of signifying John Doe is all it is. None of those exist. The one that does exist is this one. Robert Allen Rytlewski is my child, and Rytlewski, Robert Allen is me as the owner. My child's now an individual. Individuals can be considered corporations or companies. As it turns out, they are. So back to our story. So anyway, so this guy wants to do it, so he would have put Robert Allen Rytlewski and an address for Robert Allen Rytlewski, and then the owner's name and an address for the owner's name. And he went and he recorded it in the county. And it wasn't any big deal. They did it. And he got a certified copy. And because he's opening a business, he went down to the bank to open up a banking account. I can only assume it was a business account. Again, he's opening a business, not trying to do anything except open a business, right? So what would he have done? Gone down and got a business account, I guess. And gave them the DBA because, again, I don't think he knew any of this stuff. It's just the way it all lines up. Well, banks and financial institutions may require proof of registration before engaging in any transactions. And so he opened up his bank account, through which he ran his business, which was, taking in checks from people and paying other people. What are most business bank accounts used for? So nothing strange there until October of that year, which had never happened before, till the October after he did this. He got a check from the Treasury. Treasury sent him a check. United States Treasury, State Treasury, Treasury of Vatican, I don't know. Just the Treasury sent him a check. He got a check sent to him. He wasn't expecting, let's put it that way. Didn't know what to do with it. What's this for? What do I do with it? Yeah, eventually they decided to cash it, see what happens. And nothing did happen until the next October. They sent him another check. So he cashed that one, and last October, for the third year in a row, he's gotten a check. The last one was for like $65,000 that he's put into his bank account. They were sending him checks, and he wasn't going to ask any questions. So the only thing that had changed different is he had done a DBA where he put his all capital letter name as the business and put himself as the owner and had them tied together with addresses, and now the owner of that business is getting mail. And that mail was a check. That's that lost mail we're not getting. And that's great. I mean, wow, that's really wonderful. However, there's a little bit more to it, because as it turns out, C, who this happened to, is talking to B about something else because he's got some kind of court situation going on. C's got a court problem talking to B about what he might do. And so his registration, although he did it, wasn't recorded properly, or it would have been presumptive evidence, at least, could have been conclusive evidence in all courts of law that he was the owner. And that isn't so much because he did anything wrong, it's because it's not being recorded properly, because we're really not taking it to the seat of justice. We're just going with the names we see on buildings or whatever without really thinking about what it says. So that's really what this video is about, but you can see the interest, right? There's really no reason for that not to happen. That would just kind of make the thing about the checks that the video I did before make more sense. If you can tie the all capital letter name business to you, and let's say you're somebody who's doing EFTs now, which I don't do, but if you did that, but you gave that to the bank so you could do transactions, you might make it easier. You might be able just to put the numbers in the box instead of writing the words out on the line that says dollars with an S, and dollars with an S is a weight in gold and silver. When you write the words out, you're doing a gold certificate with them, but you're also giving them legal tender, because when you look at what they asked for on the bill, it was just a peso sign, right? That dollar sign is used by 25 different countries, right? So what denomination we using? It doesn't say in there United States dollars. It just has a dollar sign in a box that you put numbers in. I really think that's what you should be able to use your checking account for. You just put the numbers in, don't fill the rest out, sign it, give it to them, and they would get paid the legal tender. But because we haven't claimed the ownership of the property, we can't do that kind of transaction. It's a possibility. It's one of the things to be tried. But if you have a bank account open now and you've gone and you've gotten a DBA done, which a number of people have, and all I'm saying now, guys, is I just don't think it's quite recorded in the right place. It doesn't mean it isn't valid. Go take it to the bank. Say, I want you to record this, that I have claimed the ownership of all caps, and start telling people it's a business. I got a certificate. I'm the owner. It's my property. Make sure that the system reflects my ownership of the property, which is the bank account. And everything in the account is yours. So what is the thing about a seat of justice, and why is that important? Well, let's first do a little thing here. So seat of justice is county seat of government. There's specific places within a city, right? It isn't just the city. Like the seat of justice isn't the city of Grand Rapids. It's a place in the city of Grand Rapids. The seat of government isn't the city of Lansing. It's a particular place in the city of Lansing. And so the seat of justice and county seat really mean the same thing. And a seat of government, it looks like it's used for like where the state capital is. But here's what it says in the revised code for the county clerk. The county clerk shall keep his or her office at the seat of justice for the county. Okay, so what we're really looking for in Michigan is the county clerk. Excuse me. Lowercase county clerk, not the uppercase county clerk that when you walk in, there it is on the door, uppercase county clerk. I'm afraid that's the wrong office. Right person, wrong hat, wrong office. We're trying to find this other place where they have their other hat on, and the de jure county clerk, which is in the seat of justice. Michigan Constitution, local government. Article 7. Subsection 5, offices at county seat. The sheriff, county clerk, county treasurer, and register of deeds shall hold their principal offices at the county seat. The sheriff, the county clerk, the county treasurer, and register of deeds shall hold their principal offices at the county seat. None of those are capitalized. It's not the register of deeds that has register of deeds on it in Michigan. That's not the right place. I really believe the register of deeds are talking about would be the county auditor. If they hold have the same duties as the county auditor in the state of Washington, because in the state of Washington they use the Torrens registry system, and it says the county auditor shall be the register of titles. And registering a title is just the same as registering a deed, because that's what it is. It's a title deed. See what I'm saying? It's not the big register of deeds, it's the little register of deeds, the county auditor, who's registering the titles. So anyways, wherever this county seat is, you're going to find the sheriff. It didn't say 10-star sheriff, capital letter sheriff. Right? The sheriff is the king's main businessman. It's probably actually the clerk or the judge of probate as opposed to a probate judge, although it probably is a probate judge in another office of the judge of probate. And I'll try to show that here in a little bit, but okay, hold their principal. So their principal office is at the county seat. Doesn't mean they can't have other offices, but the principal office, the one we need to find, is at the county seat. It's where you want to take your paperwork to. Now yours may not say county clerk, it may say county recorder, but I bet you if you look in your law, it's lowercase. When you look at the statutes that go with doing the DBAs, fictitious names and so forth, right, they use lowercase. Okay, so North Carolina, as Jim Drenneman suggests, the county seat designation most likely has evolved as a shorthand description of the location of the courthouse, the county seat of justice. Thus, if the county moves its courthouse, it will also in effect move its county seat. Now we're talking about the county courthouse here, not the one they're taking us into. That's not the county courthouse, I don't believe. It's the location of the courthouse that determines where the county seat is, not vice versa. While there's no mention of the county seat, it is clear that the county board of commissioners can redesignate the location of the county courthouse. So, right, who would know? Well, the county board of commissioners would know where the county courthouse is. In addition, the Board of Commissioners the authority to designate a new location for the courthouse and its various parts. So, various parts of the courthouse. If the traditional location of the courthouse has become inappropriate or inconvenient for performing functions and posting notices required by law to be conducted and posted at the courthouse. In other words, they're going to take that shit away from the courthouse and go put it someplace else. They're going to have when they say sail on the courthouse steps, it'll be some other courthouse's steps, not the courthouse steps. The same with the postings, right? They're not going to be posted in this courthouse necessarily. It's a courthouse that is a courthouse that, we don't see it being used as a courthouse. Indeed, many local acts that establish county specifically designated a particular location for the site, right? So there's been a particular location designated. And go over here real quick. So this is in Michigan, Kent County Courthouse, the history of the Kent County Courthouse. It's the seat of justice, the Kent County Courthouse, right? So 55 years, the Kent County offices had been watered in much divided family. November 1833, 3 guys, commissioners appointed by the governor of the territory, came and designated the place of the seat of justice of the county of Kent. The place selected was what was known as Public Square or Fulton Street Park. They set a stake there. Boom, seat of justice. And I had a courthouse there at some time. It was used for county. This was used for county purposes, county court purposes. Again, county court purposes, but not everything. And meetings of Board of Supervisors. The annual elections, local general, were held there in some years during the village days. The office of the county clerk, register, and treasurer were never kept in either of those buildings. So where the county clerk, the register, and treasurer are is where the seat of justice is. Again, you see a courthouse, you think it's the courthouse. It's just a function of the courthouse. It's not necessarily the courthouse. Big ass court building we go into for all these court cases, it is not the one we're looking for. It's going to be something else. Charles H. Taylor, who was elected clerk, one testified that he kept the office where his place of business was, using a little desk with about 25 pigeonholes. Right, that right there was the seat of justice. Those 25 pigeonholes, because it goes with the clerk. So then what happened? And that year was purchased for $1,000. Ground at the corner of Lyon and Kent Street unfortunately doesn't exist anymore, and a building placed thereon, in which has since been kept the office of the clerk, register, and treasurer. Again, this is written 1899, quite some time ago, but for 55 years or so, or quite some time, it had been kept there. This was 1860, so for 30 some years, where the clerk, register, and treasurer were, and for a portion of the time of the judge of probate and the superintendents of the poor. All right, so they come there sometimes, not all the time. And when they come there, it's as the judge of probate, not a probate judge. And then we got these superintendents of the poor, and this in itself blew me away. Right Reverend G.O.D. Gillespie, Chairman of the Board of Corrections and Charities, Grand Rapids. Why am I talking about that? The following representative state boards and institutions were present. Chairman of the State Board of Corrections and Charities, Secretary, Assistant Superintendent of the State Public School. I think what we go to now when they talk about our state public schools with an S started as one state public school, and it was under this heading of corrections and charities. But we'll see later that this dude here is a bishop of a Episcopal church in Grand Rapids, and he was the chairman of the State Board of Corrections and Charities. And if that's the case, then this is the guy today, Episcopal Diocese of Western Michigan. All right. So back in 1920 something, I think, is when I found this. I don't remember the date that I found this in, because I was looking to find out who these superintendents of the poor were, and we'll find out who they are shortly. But they answered to this bishop, who is an Episcopal bishop from the Western Michigan Diocese of Western Michigan. And this is the guy that's there now. They seem to be having problems there from what I was reading, but not that that matters. Okay, so anyways, so I was just going through to figure out, where the hell it is, but basically it was a building. Wherever the office of the clerk of the county is, that is the seat of justice. Also the county seat. Okay, so anyways, back to this one here. So the reason this is important, this is the Michigan law that covers this doing business as that you put in the county. And it says, unless the person files in duplicate in the office of the clerk of the county. Right? It didn't say county clerk. It says office of the clerk of the county. And the person shall pay a clerk a filing fee of $6. Should cost $6 to have it filed. They shall certify the duplicate and return it to the applicant. This act contemplates only fictitious, misleading, or uncertain names, so it would not require filing by a person who used his surname as part of the name of his company. The problem with that is your surname is only ever coupled to your proper name. Surname goes with your proper name. Right, go look at the definition of surname. It goes with your proper name. A couple of interesting things in here, though, as barring recovery. So this is out of the annotated laws. It gives quite a bit of read between the lines stuff. When a plaintiff doing business under assumed name without having filed the certificate required by the statute, and the transaction upon which he finds his action is an intrastate one, judgment non obstant vertigo for the defendant is justified. What that means to me is the bank, the plaintiff, has to have a doing business as assumed name also, or they can't bring an action into the state courts, because that's the whole reason for this DBA thing. Is if you don't have a DBA registered, you can't bring an action into the state courts. Person doing business under assumed name may bring an action ex delicto without filing a certificate under the assumed name. So you can bring one, though, under your assumed name, Robert Allen Britluski, action ex delicto, which basically is saying that fraud's been done. So that's how you could counterclaim if you really want to take the stuff into court, which I really don't want to. I'm trying to do all this out of court, but in court. You're being sued by the bank right now in a foreclosure. You do a counterclaim, action ex delicto, pointing out fraud. A person is not deprived of his right to bring action ex delicto by the fact that he has failed to file a certificate in compliance with this section. When plaintiffs in an action of a sump prepare and sign the certificate required by this act, and one of them signed and sworn to the requisite affidavit before a notary, and the notary filled in the date of the jurat and affixed the date her commission expired, but neglected to sign her name, right? So it has no value. That's you taking a notary's seal and stuff and just stamping it on there, but not putting a signature on. Was not barred from the plaintiff was not barred from such omission. Okay, so really go look closely at what is on the notary seals on the paperwork that the bank has sent to you, and see if it's missing the signature of the notary, because if it is, it's an omission. If you point it out, now they have to fill it out. If they won't fill it out, it's fraud. Right? So you're looking for any kind of omissions on paperwork. Very important. Effective filing certificate. Filing assumed name certificate required to inform the public as to ownership of business. Beautiful. I'm the owner, and does not create separate legal entity. Doesn't change does not create another entity. It just signifies that you're claiming to be its owner, instead of being classified as an unknown owner, because it already exists. Robert Allen Britluski exists. It's existed since 1958 is when it was recorded, October 7th, 1958. I guess I might as well say it's mine. My mouse is acting up here. Okay. Assumed name certificate. Shit. I may have to stop the video. Stop the video. Sorry, I gotta fix my mouse. Okay, I think we're back. Where was I? The several county clerks in the state are hereby authorized to reject any assumed name which is likely to mislead the public. So they're going to say, well, you can't do that. It's like your name. right, first, that's going to be one of the reasons they're going to tell you, because they really don't want you to do this, because when we do it properly, it will be presumptive evidence in all courts of law. There will be an address now to send mail to the owner of all caps instead of to all caps, and you may get checks from someplace that you didn't know you had coming, because now they have your address to send it to. So we really want to get it into the right office. That's what all this is about now. Interesting. The Attorney General may not advise County Clerk whether specific proposed name should be rejected, since decision must be that of the clerk, and it's subject to a judicial review. Excellent. A clerk's decision is subject to judicial review. If you don't like what the clerk gives you for an answer, you ask them to go get a judicial review, or you demand a judicial review. Not that they send it to the Attorney General, prosecutor, district attorney, whatever they call them. No, I want a judicial review, because you're talking to a clerk. That's the administrative arm, not the judicial arm. It's an administrative magistrate, and we want a judicial magistrate to give us a judicial review. And judgment of Attorney General in any particular case, determination of which depends upon its own peculiar facts, may not be substituted for judgment of the clerk. In other words, the Attorney General can't speak for the clerk. Clerk can only speak for themselves. And why is that important? Or how can we use that? Well, this is what a Supreme Court judge said here in Michigan. And this was at one of these conventions of the Commissioner of the Poor and County Agents, headed by a bishop of an Episcopal church who was the state commissioner of corrections. I mean, we're talking about the guy over the prisons is a bishop. It still blows me away. Is a bishop of an Episcopal church. At least used to be. Is that a Catholic church? No, I don't think so. I think they call themselves Protestants. Right? Got a Protestant bishop over the frickin' prisons. Hallelujah. The governor cannot remove a police officer or marshal where he is appointed, but he can remove any sheriff or any elected officer who fails to do his duty. And when they understand this can be done, and it has been done, you will find the law will be well enforced. That's what we can use against these clerks at the Secretary of State or the county or wherever it is. It isn't one. If they're keeping you from doing this process properly, right, well, number one, they're aiding and abetting a criminal, because you're a criminal for not having done this. But they're also negligent in their duty, and I don't really need to know how. So I don't have to know how to fill the paperwork out. I just need to know that I'm supposed to fill the paperwork out, and I'm coming down to have it filled out, and I'm expecting them to follow the law, period. If it isn't done by the law, they made a mistake. How will I know it's been done by the law? When I can see that it's presumptive evidence in all courts of law, it's been done properly. When I have that kind of evidence in my hand, they have done their job. It's really all they've done. They've done their duty. If they're not going to do their duty, you take them to the governor. And we're going to talk about the Secretary of State and the Ombudsman in just a second, but we're not quite there yet. Certified copies of original renewal certificate. Upon request, payment of $2. The certificate, certified copy original. Okay. So we paid $6. We got it. We got it filed, and for $2 now we can get a certified copy. However, certificates, alphabetical index, indexing, and filing fee. I don't know what's wrong with my computer today, but the county clerk shall keep an alphabetical index of all persons filing certificates provided for in this act, and for indexing and filing of the certificates shall receive a fee of $10. We paid $6. The county clerk is now supposed to put in an alphabetical index of all persons filing certificates. So now we want to file it into the alphabetical index, and for that, that's another $10. A copy of the certificate duly certified by the county clerk in whose office the same is filed shall be presumptive evidence in all courts of law in the state of the facts contained in the certificate. And the certificate's going to say you're the owner of your all caps. More, as importantly, it's going to say, without saying it, that the state agrees that all caps is not you and that this is your name. And so if somebody wants you, they need to be coming after you in your true name. Ritluski, Robert Allen. If it isn't that, it isn't me. Now, what the hell? Department of State, Office of Secretary of State. This is from the Arizona Secretary of State's website. The book they have for doing the business registration. A certificate of registration issued by the Secretary of State under the provisions of this article, or a copy thereof, duly certified by the Secretary of State, shall be admissible in evidence as competent and sufficient proof of registration of such mark in any action or judicial proceeding in any court of competent jurisdiction in the state. Competent and sufficient proof. You don't need to have any other proof to prove that you're the owner than this certificate. And so Joe in Arizona went down to do this a couple weeks ago, and if you remember the email I sent out where he had taken in what he had done in the county, because you can do it in the county also, and put it into a court case and said that he was the owner. Where's the contract? And the judge looked at him and said, I'm going to stay the proceedings and recuse myself. And as he was leaving, winked at Joe and said, after all, it's just business. And out the door he went. So Joe had tried to do this at the Secretary of State, and the Secretary of State's office wouldn't let him do it, wouldn't let him do the form just using his all caps. They wanted to put a descriptive word. They did the same thing to Bobby in Arizona. In fact, Bobby did it anyways, and they spelt his name wrong. They spelt his last name wrong. On Rose, they don't want to put the address in the proper format. Well, and that's at county level for Roe, but back to Joe. So Joe goes and he contacts the ombudsman of the Secretary of State and put in a complaint. And so that was, last Friday or so. Well, this week, the ombudsman, two people from the ombudsman's office in Phoenix drove down to Tucson to meet Joe, along with a couple of the people in the Secretary of State's office in Tucson who had told Joe that he couldn't do this, he couldn't use his birth certificate name, and they admitted that it was only a verbal internal policy, and it's been left that either they're going to change it or the ombudsman will file a criminal complaint against the Secretary of State's office. All right, Joe called the ombudsman and bitched. We can call the governor and bitch. We can write the governor and bitch and say the clerk is not doing their job. They're not following the law. All we want them to do is follow the law. Because the law is real clear. Upon a payment of $10, the payee shall be entitled to 2 certified copies of the certificate without extra charge, with additional copies at $1 each. The Circuit Court of the County and the Office of the County Clerk. That reads really funny. The Circuit Court of the County in the Office of the County Clerk. It sounds like the Circuit Court of the County is in the Office of the County Clerk. And then 25 pigeonholes. Of which the certificate is filed shall have jurisdiction of an action brought against non-resident person, but this provision shall not be construed as depriving any other court of jurisdiction. Okay. Violation of or penalty. You're guilty of a misdemeanor if you don't do this. And each day, and any person or persons shall violate any provision of this act shall be deemed a separate offense. Every day is another offense. it can get you 30 days in jail. That's why we need to do this. Why we need to do this. And if they don't allow us to do this, right, they're causing us to violate the law, and therefore they're derelict in their duty. And according to the Supreme Court judge, you can take it to the governor. So the first thing you tell them is, I want a judicial determination on your judgment. You're just an administrative magistrate. I demand a judicial magistrate look at this and make a judicial determination. And if I can do this or not. Send them to the back. If you don't like the answer, you can take it to the governor. But we need to be doing this in the office of the county clerk or the clerk of the county, not the big sign that says county clerk's office. Wrong way around. And shall be prohibited, here's the big thing, from bringing any suit, action, or proceeding in any of the courts of the state in relation to any contract until after full compliance with provisions of this act. That's why the plaintiff can't do this if they don't have a DBA recorded, if they don't have their fictitious name recorded, right? They can't use the state courts either. So point it out. I don't believe that they have a business license. You haven't seen their certificate of good standing. You haven't seen their license to do business as. You don't believe that they have access to the courts. Arizona, any person other than a partnership transacting business. See, now the partnership would be, I think, you and your wife are the partnership. Or designation not showing the name of the owner of the business shall record with the county recorder of the county. See? County recorder of the county, lowercase. It's how it's written in the law. I bet you the county recorder of the county is in the seat of justice. Good chance. A person or corporation doing business contrary to this section shall not maintain an action upon any account or contract. Again, you can't bring any action into court unless you've done it. Joe did it. He brought it into court. Judge stayed the proceedings, recused himself. Told him it was only business. To knowingly display, cause, or permit to be displayed, or have on a person's possession a canceled, revoked, suspended, fictitious, or fraudulently altered driver's license. If your driver's license in Arizona has your fictitious all capital letter name on it, it's a fictitious driver's license, and you're just guilty of a misdemeanor. And I like this one, fictitious name of a child. The court may order upon request of any interested party that a child be adopted shall be referred to by fictitious name in all proceedings before the court if such would be the best interest of the child. Well, who's the child? Child. Robert Allen Bretluski. Or is it child below? I don't know. If this is my true and real name of the child, and then this is my fictitious name of the child, I don't know. I just know that the real name of the child shall be kept in a sealed envelope in the court file and shall not be opened except on order of the court. So here we go again. If you're in your birth county and you've done this already, there's no reason not to go down to vital statistics with your certificate that says you're the owner of all caps and tell them you want your property. Because all these places are just depositories and repositories of records. But those are your records, right? Now you have your ownership papers. You didn't have ownership papers before. You didn't have a certificate under the seal of a court of record that said you were the owner of all caps. And once you are the owner of all caps, it's all yours. And remember, banks and financial institutions may require proof of registration before engaging in any transactions. What does transact mean? It means to prosecute negotiations, to carry on business, to have dealings, to carry through, bring about, perform, to carry on or conduct, to pass back and forth, as in negotiations or trade, to bring into actuality or existence, Right? We got a lot of contracts aren't done yet because they haven't been transacted. Why aren't they transacted? We haven't given them our business information. The word embraces it in its meaning, the carrying on and prosecution of business negotiations, but in a broader term than the word contract, it may involve business negotiations which have been either wholly or partially brought to a conclusion. Right now, you're the only one that signed any papers. They haven't. They won't transact business with you because you're not the owner of all caps. They don't have any record of it. Take your record down to the bank. If you already have in your possession a release of mortgage from a bank, send that with a copy of your ownership papers to the bank and say, hey, I want my securities back now. Maybe that's the evidence they need to see. I'm just thinking of things to do with it, right? But to me, the big thing is I want to get it in the right office, recorded, so it's presumptive evidence first. An agreement between two or more persons who, for preventing or putting on an end to a lawsuit, adjust their differences by mutual consent. That's what a transaction is. In the matter which they agree on. For preventing or putting an end to a lawsuit, adjust their differences by mutual consent. I guess you send a copy of it to the bank that you have your loan with, or to the closing agent who was acting for the bank. You can give him a copy. You can put a copy in your court case and then ask for an ex parte hearing to determine the rights, title, and interest of the property. So, okay, that's enough on that one. Transactions regulate only the differences which appear to be clearly comprehended in them by the intentions of the parties, whether they be explained in general or particular manner, unless it be necessary consequence of what is expressed, and they do not extend to differences which the parties never intended to include in them. And whatever that means. But it sounds to me, well, what was the intention? My intention was I'd sign this paperwork and you were going to loan me some money, and I've never seen a loan from you. You didn't sign the agreement. My intention was for the closing agent to properly close the transaction between myself and the grantee. That's enough on that one. Let's look at this one again here. Superintendents of the poor. Superintendents of the poor. Is that the one I want to look at? Oh. Talking about county agents. The drain commissioner is the county agent. County agent was like the truant officer. He's like the custodial marshal over all the orphans and so forth that are in the realm. That's why they want to call you Mr. all the time, or Mrs., or Ms., or whatever it is, right? They want to use that identifier, right? Because a Mr. would be either a non-adult, you'd be a master, but if you're Mr., I think you're still under the age of majority. A Mr. also makes you an officer in the military, such as Mr. Christian, or Mr. is used as a warrant officer. The county agent is officer of the court and under the general supervision of the judge of the court and shall serve at their pleasure. Okay. I don't think that this is really the one that I wanted to spend too much time on. Sorry, I got pieces all over the place. And get to the right one. So, county superintendent of the poor, right? We were looking at I guess I closed it. In Kent County, the treasurer, register of deeds, county clerk had offices together, and sometimes the superintendents of the poor met there, and also the judge of probate. Well, the county superintendents of the poor, their powers have now been transferred to the County Board of Social Welfare. So if you see that you have a County Board of Social Welfare, that would have been the same as the Superintendents of the Poor. And see, all these things are under the jurisdiction of the Court of Chancery that we're talking about. The poorhouse and so forth is really under the Court of Chancery. Excuse me. All powers, now this one's funny, county departments. All the powers and duties prescribed in any law of this state incidental of transfer of the powers and duties therein provided for shall be transferred to and be vested in the several departments, county departments of social welfare. It sounds like other county departments' powers have been transferred to the County Department of Social Welfare. Estate. An estate means, and this is in the Social Welfare Act, an estate means all property and other assets included within an individual's estate that is subject to probate administered under Article 3 of the Estates and Protected Individuals Code, yada yada yada. Property means the term as defined in sections of Estates and Protected Individuals. I have to go look and see what that is, but I bet you it pretty much covers everything. If the county establishes a Department of Public Works, the Public Improvement Agency with Drain Commission designated as county agent pursuant to Public Office Improvement Act, yada yada yada. The Office of the County Agent is created. The county agent is an officer of the court and under the general supervision of the court are the judges of the court. So judges of the court didn't, when they just use the word court, which court are they talking about? Circuit court? Could be. The circuit court clerk told Roe that to him circuit means county, and we're looking for the county court. The judge of probate in each county may appoint one or more suitable persons of good character to be qualified, trained, experience other than the county agent or assistants to act as probation officer. So that's one way to find out who the judge of probate is who appoints the probation officers. They have an annual meeting of these county agents. The report of the repaiser shall be filed in the office of the judge of probate, right? There's that thing. And the office of the judge of probate isn't the same as probate judge or probate judge's office. It sounds like his office is going to be where the county clerk and so forth were, because they said sometimes that's where they went to. And so again, I think this guy who's sitting here as the office of the judge of probate in the de jure side of things is the one that has the judicial power of the county, of the circuit. And he's not in the probate court. Could actually be here in Michigan. The family court, I believe it is, isn't in the court with the rest of the courts. But what we're trying to find out is really simply just this: where is the seat of justice, right? So if you just take your law in that says how you're trying to do this, and it says the office you're supposed to go to, like the office of the clerk of the county, and you point at it and say, that's the office I'm looking for, and start asking, where is the county seat? And if they tell you, well, you're in it, it's Grand Rapids. No, that isn't what I mean. Where is the place of the county seat? The same lady that is the county clerk is the clerk of the county. She's just wearing a different hat. You may go and ask them, where is the office of the clerk of the county? Just go ask them, where's your other hat? I need to see you in your other office, or I need to see somebody who is in your other office, because there's probably a deputy clerk sitting in there. Where is the office of the clerk of the county? And if they won't tell you, say, do I need to call, do I need to complain to the governor, because he can have you removed from office. So tell me what I need to know so I can comply with the law, because they're keeping you from complying with the law if you cannot get this certified and indexed properly. Oh. And what do we have here? This is just some of the stuff that, hopefully, come on, baby. Here's all the things that a chancery court has jurisdiction over. Well, basically it had all the High Court of Chancery in England up until the time of the American Revolution. Boom, has all those powers. And then it had a whole bunch more added. Statutory changes and powers and jurisdiction of the court has been already stated. The statutory changes and powers and jurisdiction of the Chancery courts have mainly been additions and not limitations. Jurisdiction means authority imposed by a court to determine a controversy, and the powers of the court are its right and ability to enforce its determination. The principal additions to the power of the court are as follows, given in order of time. Power to order a bill to be taken for confess, power to issue execution and enforce money decree, power to bring defendants before a court by publication, power to divest and vest title and property by decree, power to issue attachments to impound property. Any of these things sound kind of familiar? Power to appoint commissioners to execute a conveyance, release something or other in the name of either party or of himself. Power to appoint administrators ad litem, guardians ad litem, when necessary. Principal additions in jurisdiction of the court are following. Jurisdiction to empanel jury to try and issue a fact. Well, that's a power of the Chancery Court now. Jurisdiction to proceed against non-resident absconding defendant by publication. You know, they do things by publication. Decree a divorce and alimony. Yep. In rem. Yep. Proceed against real and personal property of non-resident defendants. Yep, because you haven't registered your name to say where you're at and given the address of the owner. Jurisdiction to proceed by attachment, appoint to administer and wind up intestate's estate, keep corporations in line of their duties and to decree a forfeiture of their charters. Excellent. That's why we want to be seen as a company, so that we're dealing corporation to corporation and say this corporation isn't within their charter. That's what a quo warranto is. That's one of them against a corporation. Jurisdiction over the persons and estates of idiots, lunatics, and persons of unsound mind. Drain commissioner. Jurisdiction to consent to and decree a sale of property of infants. And married women. If the court had inherent jurisdiction to do this, the statute certainly settled all doubts and enlarged that jurisdiction. There's jurisdiction to prevent the usurpation of office and to declare an office forfeited. So you can take it to this court also. When we find the seat of justice, that's the clerk you want to take your complaints to. Into that office. Jurisdiction of all civil causes of action triable in the circuit court except for injuries to persons, property, or character involved in unliquidated damages. So the Court of Chancery has lots of jurisdiction. So it's just, where is it? And it's in the seat of justice, because justice is equity, period. Now this is the interesting thing. For where Roe is in Geneva, in Kane County, Illinois. In her foreclosure, she had gone to the county recorder to get a copy of the lis pendens that had been filed there. Lis pendens is a suit pending that says there's an action going on in your foreclosure. But they don't mail it to you. You wouldn't even know there was one in the property file unless you went and looked in the property file. And because they don't know where to send it to. They're saying they don't have your address. So she got a copy of it, and she went over to where her court case is going on and was asking the clerk why this hadn't been put in her court case. Said, "Oh, we can put that in. We can do it for you." But then she said, "Well, the name on this one is different. It's the 16th Judicial Circuit, Geneva, Kane County, Illinois." It says on it. Has the name of the city, Geneva. Her court case doesn't have Geneva. It just says Kane County, Illinois. And she says, "Why does this say Geneva, Kane County, Illinois?" And the clerk said, "Oh, that's because of the county seat." And so she said, "Well, where is the county seat?" And he said, "Well, it's at the Judicial Center." And if you go to the Judicial Center, there's like 8 buildings or 6 buildings there. And the land used to be a Jesuit seminary that they sold to the county. And the county tore down all the buildings except one. And the one building left is Building A. And Building A is the only building, if you're looking at business licenses, that can do business in the city. And when you go into that building, it has this big stairwell you walk up to, and you get up at the top, and there's a courtroom up there. And that courtroom looks a lot like it used to be a church or a cathedral. Got really nice pews and stuff in it. And then a bench and a bunch of chairs where a group of people would sit. Like 5 commissioners, 3 commissioners, 2 commissioners, however many commissioners it would take. And just very interesting. And so the other type of offices in there, that's where the county treasurer is, it's where the county auditor is, it's where the waterworks is, it's where the Department of Social Services is, it's where all these other places we've talked about so far, their offices are. And there is a courtroom in there. But what we haven't found yet is where the clerk's office is. But now Ro's pretty sure that's where it is. And I'm going to do an audio with Ro and have her talk us through this, because it was a very interesting day just going and looking at this stuff. But anyways, it's a particular place, and we need to find the seat of justice, and we need to find the office of the clerk of the county, or whatever yours is called, the lowercase. And that's where you need to submit your paperwork to. Okay, that's good for now. We'll talk to y'all later. See ya. Bye. Maybe.